It's 10 o'clock now. We do have 275 people who have registered now, to particularly online right now. So I just want to welcome everybody to the launch of the new private sector contract. I am Paul Sheridan, Director of Main Contracting Services with the CIF, and I'll be the chair for the next hour. Today is about leadership and collaboration. It is the demonstration of a joint vision and the coming together of contractors and surveyors, and how the industry can work together to create better value for our clients. This event is hosted jointly by the Construction Industry Federation, Engineers Ireland, and the Society of Chartered Surveyors of Ireland. The schedule for today's event will begin with brief statements from the leaders of the three bodies who have joined us here today. Tom Parlin, Director General of the CIF, Maurice Buckley, President of Engineers Ireland, and Shirley Coulter, CEO of the SCSI. Following this, Kieran Fahey, Consulting Engineer Arbitrator and the Chair of the Private Sector Contract Standing Committee, will then give us details on the background, objectives, and the management of the contract. This will be then followed by a series of short presentations by our panel of experts on various aspects of the contract. First up will be Anthony Hussey of Hussey Fraser Solicitors, and he will use clauses to demonstrate the approach taken by the drafters. John Curtin will then follow Anthony, who is the Director of PJ Hegarty and Sons, and he will discuss an acceptable balancing act for contractors in this contract. Thirdly, Conor Hogan, Director of JC Hogan and Sons, will take us through the valuation mechanisms contained in the contract. And lastly, Kieran Fahey will return to take us through Clause 13 and the dispute mechanisms within the contract. Leaving part 3, we'll then enter part 4, and I'm delighted to welcome Eamon Conlon, solicitor, who will give us an outside overview of the PSE by reference to other alternative forms of contract, its balance, likely use, and potential amendments. We will then host a question and answer session with our panel of experts and aim to finish at 11 a.m. We would encourage attendees to submit questions throughout the event. This is a tight schedule. Therefore, I'm reminding all contributors to keep to their time allotted. Thank you. I will now invite Tom, if you could say a few words on behalf of the CIF.
Right. Thank you very much, Paul, and good morning to everyone, to our panel and to all of the people that are listening in online and tuned in. It's a strange enough morning. We were just chatting earlier. We're all awaiting a cabinet announcement today with regard to the new guidance about living with COVID. And indeed, we have been living with it for the last 6 months plus now. So I think it's a very, very important and a timely event for the industry. And COVID, I suppose, has shown us a lot of things, but it certainly has shown us that the current suite of contracts are not equipped to deal with these types of events or to facilitate cooperative practices. So I think the launch of this contract sets a new standard in how clients, professionals, and contractors can work collaboratively to create better value for clients by supporting contractors to do what they do best, and that's to build quality assets. So I'd like to thank members of the Standing Committee, particularly Engineers Ireland, the SCSI, my own members and colleagues for the very significant collaborative and joint effort in producing this document. I'd also like to mention Martin Lang, who was highly involved in this work until his retirement in April. So thank you all and enjoy the rest of the event.
Thank you, Tom. May I invite Maurice to say a few words on behalf of Engineers Ireland?
Yeah, thanks, Paul. We in Engineers Ireland are absolutely delighted to be part of the launch and part of the development of this contract. It's a great collaborative effort, very much targeted at the private sector and those situations where the employer wants to retain design responsibility. As Tom said, in my own experience, the contract is so important nowadays to the success of a project and to get the contractual terms right. And this contract, I think, will really help get that right balance between risk and engagement and the different parties. And what we're particularly happy to see is that the contract is very largely standardized. There should be just very minimum amount of adaptation project to project. So we're designers, we're builders. That's what we want to stay working at, not the fine points of contracts. I really want to thank Kieran Fahy for leading the way on the development. And also, I just mentioned very quickly, we had a small team of reviewers, Harry Meehan, Siobhan Fahy, Neva Higgins, and Brian Bond, who I want to thank as well. So I look forward to hearing the presentations. Thank you very much.
Thank you, Maurice. Shirley, would you like now to share a few words?
Yes, thanks, Paul. The SCSI is delighted to be part of this joint alternative private sector contract with our colleagues in Engineers Ireland and the Construction Industry Federation. And as you've already heard, today's launch is a result of extensive engagement between the bodies and our associated member representatives. And I'd like to echo the appreciation already expressed by Tom and Maurice to all of those involved in the development of this contract for their hard work and dedication in bringing this to completion for the benefit of members and for clients. In particular thanks to SCSI reps Conor Hogan and Paul Brain, and of course the wider standing committee. While this is a new contract, we are confident that there will be a high level of familiarity for all construction professionals and consultants, given its close links with the Public Works contract. We believe that all stakeholders will welcome the increase in contract choice for clients, consultants and contractors that this new contract provides, and the appropriate apportionment of risk for all involved. Notably, the contract also includes prime cost sums, which mirrors other private sector contracts, but is a significant change to the Public Works contract on which it is based. We believe that as a result, this will help provide clients with an enhanced level of cost certainty, which is of course welcome at all times, but most particularly in this new COVID-19 operating environment. Finally, from an individual membership perspective, we have no doubt that the options for consultants to be appointed as contract administrator, for example, building surveyors making amendments if appointed, will be a welcome addition with reduced administration when amending contracts. Ultimately, the template contract will provide other consultants with the flexibility to draft a contract more appropriate to their needs and provides a good reporting structure for dealing with changes or variations in a timely manner. Our speakers this morning will take you through the detail of the contract, and I'm sure that you will all quickly recognise that this new contract is a most valuable and timely addition to the construction sector. So I wish you all participants enjoyment of this morning and encourage you, as the others have done, to submit your questions. Thank you.
Thank you, Shirley, and thank you, Maurice, and thank you, Tom. May I now invite Kieran Fahy to step forward and give his presentation covering the background, management and objectives of the contract. Thank you, Kieran.
Good morning all, and thank you, Paul. Can you hear me? There's no difficulty? Okay. What I want to do is say a few words about the background, how this came about and how we got to where we are today. And it has actually been quite a long road. The starting point is probably a paper that Anthony or Tony Hussey and I gave to Engineers Ireland in July 2013, when we specifically looked at the possibility of using the Public Works form of contract, PWC, in the private sector. And we concluded that this was a very obvious option to pursue. And we concluded that the PWC is well written, it's well presented. It's understood within the industry. Even in 2013, we were saying that. People know how it's structured, they know how it's worked. So we felt that with suitable amendments, that the PWC was eminently suitable for use in the private sector. Subsequent to that, in early 2015, a group of 5 people came together, and they comprised myself and Tony Hussey, together with John Curtin, Conor Hogan and Kieran McIntyre. And we took as our starting point essentially the PWC, the employer design versions, CF1 or CRS and CF3. And we worked through those on a clause-by-clause basis to come up with a conditions of contract which we felt would be suitable in the private sector. That exercise was completed in late November 2015. And in the following year, 2016, the proposed conditions of contract was circulated within the industry to various organizations that we felt would have an interest in this. And they come back with comments and suggestions. And that continued really throughout all of 2016 and indeed even into 2017. And in many cases, these were extremely detailed, and it led to a further review of the document on a clause-by-clause basis by the original 5 people. And that continued up to July 2018, when the conditions of contract, as you see it today, was finalized. It really hasn't changed since in the past 2 years, since July 2018. Thereafter, there followed a period of trying to get, I mean, we basically had a document which had been put together by 5 individuals just acting together. So it then was up to a situation to see if we could get various organizations to agree to take on the document and publish it in their name. And that exercise continued into 2019. And there were certain formalities to be gone through. And say in the case of Engineers Ireland, these were only completed in May 2019. And it was about that time that the 3 bodies, Engineers Ireland, CIF and SCSI, agreed to publish the document jointly. And it's very much a joint and equal engagement by the 3 bodies. In the rest of 2019, there was ongoing discussion about how the document would be managed in the future, and that was only agreed and finalized at the end of 2019 with the intention that the documents would be launched in early 2020. Now that has been delayed by COVID-19, and that's why it has taken us to get to today. Could I just say a few words about what the objective of this form of contract is? The intention is that it's very much a joint effort, as I said, between the 3 bodies. Their names are presented across the front of all the documentation alphabetically to indicate this. The intention is that the documentation will be produced in soft copy only. It's a sort of a move, if you like, in that that's the way we see the world going. The documents will be freely available to anybody who wants to download them. In a change, it is intended for not only building work, but for civil engineering work. It's for both. It's for construction work generally. The form of contract is seen as suitable for that. The intention is that it is for medium to large projects, with those undefined, but fairly generally understood, I think. In terms of where the document is coming from, I should read from you the 2nd paragraph of the preamble. I think it's very important. It sets out what this form of contract is about. And I read, this conditions of contract has been drafted with the object of achieving a fair and balanced allocation of risk between the parties in order to promote long-term sustainable efficiency in the Irish construction industry. Specifically, risk has generally been allocated to the party best able to bear and manage it. I think that paragraph is extremely important. That's the ethos, if you like, or the philosophy of this form of contract. Just briefly going on from that, you will see, or you will have available, the bodies have agreed to set up what's called a standing committee. It's a permanent committee comprised ultimately of 7 people. There are 2 nominees from each of the 3 bodies, and they have the option, the committee has the option of co-opting on one other person, which they've done, and they chose a chairman who happens to be me. The details of that, the mandate of the standing committee, and indeed the names of the standing committee members are available on the website available to you. So that's where we're at, and that's where we hope to go forward. It's recognized that this document, the documents will need to be updated on an ongoing basis, and the intention is that will be done and they'll be made available on the website. Can I just say very briefly, just to finish, a few words of thanks. Firstly, to the group of 5 people, 5 individuals who did a huge amount of work to put the documents together. Secondly, I think I want to acknowledge the fact that we are able to use the government's public works form of contract. I think that's very significant, and it's very helpful. In many ways, the document those documents are very well put together, as I say, and it's their use, and the use of this means that this form of contract will be readily understood within the industry. I want to agree with Tom Parlin. Martin Lang was very involved in 2019 in getting the documents approved and getting the management structure set up. So that's it. Thank you very much.
Thank you, Kieran. Can I ask Anthony to take the stand and present your views in terms of how various clauses present the intention of the drafters of this contract? Thank you, Anthony.
Thank you, Paul, and thank you, Kieran. I will concentrate on some clauses, but it's for the purpose of demonstrating the point that Kieran made regarding the fair allocation of risk. And it has to be borne in mind that fair allocation, or fair anything, means fair to all parties. So the intention wasn't to redress what was already in one contract and swing in the opposite direction. The intention was to be fair to both parties. And before I go into the clauses, I know there'll be a temptation there on behalf of lawyers representing employers to perhaps put the balance back where it was in the PwC. And I would just caution against that as to whether that is appropriate. If that is done, the cost of the work will go up, and the relationship between the parties may perhaps be soured from the outset unless we have a fair contract, which we believe this is. Firstly, Article 4 in the Articles of Agreement, we've maintained the provision whereby the contractor is obliged to price for all the circumstances that he might meet, but we have deleted the sentence which says that the contractor will include in his price, or has included in his price, for all risks, whether those risks could be foreseen or not. We felt that was just going a little too far on the balance. We have deleted some of the main provisions in the PwC altogether. One of them is clause 1.10, background information. This is a clause which says that the contractor can't rely on certain information given by the employer. Now, given that that information usually includes things such as site investigations on which the contractor in reality has to rely, again, we felt it was a little unfair and we deleted it. Program contingency can operate unfairly. In theory, the contractor under clause 9.4 has priced for a certain number of days of delay. Everybody knows in practice the contractor doesn't price for those days of delay in a competitive tender. And those days can be quite considerable, up to 30 days and more in some major contracts. On clause 10.2, we have dealt with remeasure. Under the PwC, remeasure is a compensation event and is dealt with by way of notice under clause 10.3 and so on. We have adjusted that, not hugely. It's not a compensation event as such. Either party is entitled to look for a remeasure, but they must do so within 42 days of the work having been done. Clause 10.3 of the PwC contains a time bar, a condition precedent, whereby notice must be given and details must be given within prescribed times. Now, we have maintained the provision relating to notice itself, but not in relation to details. One must give details within a particular time, but it's not a condition precedent. In other words, the claim doesn't necessarily fail because the details haven't been provided. And this would be consistent with the FIDIC form of contract. And finally, under clause 10.9, which deals with employers' claims, we've put that on the same footing as the obligations and entitlements of the contractor under clause 10.3, so that both parties are subject to the same provisions in that regard. I think they're the main points I wish to make. Thank you.
Thanks very much, Anthony. Paul, will I jump in? Great stuff. Thanks very much. John Curtin's my name. I work for PJ Hegarty and Sons, and we're building contractors. And I was involved in the drafting and of the contract with Kieran, Connor, Anthony, and thanks very much for listening to me this morning. A few minutes to talk to you about this new contract, and I'd just like to chat about the balancing of the risk. Before I do, I would like to talk about something that I think a couple of the earlier speakers have touched on, and that is the fact that it's a common form. We're building contractors. We want to get onto site and build your buildings for you, for our employers. And that's our core goal. The interpretation of contract is not our core goal. Maurice touched on something earlier on, and that is that the contract has become more important to us as an industry. And in the good old days, or the bad old days, the contract was left in a desk drawer. Unfortunately, it sits beside the specification and the drawings these days. regrettable, but nevertheless a fact of life. And whilst that is a fact of life and we've got to get on with it, I think what contractors have been burdened with over the last number of years is the endurance of an increasingly complex web of amendments to standard forms. These amendments are invariably difficult to understand and interpret. They can conflict with each other and cause some degree of confusion on sites. And of course, they're invariably untested. Ultimately, they place a great strain upon the team trying to build your building. It takes them away from the coalface, and it shouldn't do that. By using the public works platform of navigation, what the private sector contract does is it helps to redress that balance. It allows our staff to get to grips with the contract very quickly and to identify their obligations quickly and, of course, with confidence. If you like, it resets the relationship that might have existed between the old GDLA and the RAAI form of contract. There's a lot of items that Anthony touched on there. There's one area I'd like to touch on, and that's the concept of the condition precedents. You know, conditions precedent are not something I would welcome. I don't believe any contractor would, particularly when they're associated with a time bar. It's in essence, what we're being asked to do as contractors is after an architect puts something new on a drawing, we're obliged to go back to him and tell him he's put something new on his drawings, failing which we would have to supply and provide that new item free of charge. It's not a very edifying prospect. However, it is the industry and the modern industry with which we work. I don't see that there's any easy way around that these days. But what we have done is we've attempted to restore the balance. So now, if the employer has a claim, the employer too must observe a condition precedent. If there is a determination to be made by an employer's representative in response to a claim, that determination has to be made within a fixed time. And if that determination isn't made within the fixed time, the claim will be deemed to have been accepted. And that's a very important departure. So it puts the pressure back on the team on site, both the employer's team and the contractor's team, to respond and to have conversations with one another and press on. When the employer's rep is to make a determination, he's obliged to consult with both parties and he is obliged to attempt to reach agreement with both parties. If he fails to reach agreement with both parties, he makes his determination, but he does so based on a fair assessment of all the matters before him and with due regard for all circumstances. So again, that's an attempt to restore the balance, to recognize a modern contracting environment, but also to require contractors to observe the conditions precedent. With regards to subcontracting, we've stitched in, and Shirley touched on it earlier on, novated, named and nominated subcontractors. Design responsibility must be identified from the get-go with the novated and the named subcontractors, because they will obviously flow through the main contractor, and obviously he'll have to be aware of his obligations in that regard. The obligation on the nominated subcontractor's design is in the traditional sense. It flows between the nominated subcontractor and the employer. Clearly, the named and novated subcontractors cannot be terminated unless they first notify the employer, and that's more or less following the public works form of contract. Okay, so look, that's my 5 minutes. Paul, if I could hand back to yourself.
Thanks very much, John. Connor, would you like to give your presentation, please?
Yes, can you all hear me? I presume. Yeah, okay, that's fine. Firstly, I'd like to thank the QS Professional Group, the Society of Chartered Surveyors, for together with the building surveyors and the project managing surveyors, for their assistance in suggesting amendments during the course of our deliberations, and the general encouragement I got from all the bodies, including all the past chairmen of the QS committee over the many years. The SCSI staff has also been a great assistance. In particular, I'll name Ed McCauley. It's always dangerous to make names, and Michelle Smith and Patrick King for helping out today. My colleagues have previously pointed out the familiarity we all have now with the public works contracts, and this private works sector contract is one of the great strengths, I think, in that it follows the public sector contract, and it enables familiarity among the construction professionals, contractors, and all sort of like-minded people. And so and as John has mentioned earlier, there's I remember when I commenced that the familiarity between the GGLA and the RAI type of contract was beneficial and allowed seamless movement, and I hope that this new contract will follow. However, there are differences in the form, and again, Anthony and everybody and John have pointed out the various differences. The first one is obviously in that we've introduced nominated subcontractors, names and specialist subcontractors. It's maybe worth noting that this doesn't appear in the public works contracts, as you probably know, and it might be worth that particularly for difficult projects that might be considered, because I think it's going to be beneficial for this contract. In terms of claim in clause 10 for claims and adjustments, there's a couple of significant changes that I want to bring to your attention. John has already and Kieran have already hinted at it, or maybe more than hinted. Clause 10.2 in the private sector deals with the adjustments of the contract sum due to changes in the quantities or prime cost sums. This is significantly different than the one that appears in the private sector or in the public sector, in that it brings in a time bar for claims in terms of quantities remeasurement. Not something maybe that John favoured, but we felt that it would be good to have an early warning system in place for remeasurement rather than it coming at the end of the contract. And in that sense, then the contractor must submit a claim for remeasurement within 42 days of that work being carried out. If the work is carried out, if the remeasurement is looked for, all linked elements are also included in that remeasurement. A simple example might be a remeasurement of tarmac, and hardcore will then be looked at as well in the terms of remeasurement. The adjustment for remeasure must exceed €500, and the 42 days is not imposed on the client side, as they may not be as aware as the contractors of a remeasurement being necessary. Clause 10.3 follows to the great extent the public works contract timelines and requirements. And in my opinion, the prescriptive and discipline imposed by this 10.3 is benefits cost certainty for contractors or cost reporting, and that's one of the big positives of the public works contract. It allows timely informing of any changes that occur and payments of any significant claims to be made at the conclusion of the contract. This is the changes that have been brought about in the private sector contract are that 10.35 introduced a new concept of a reduction of entitlement if the employer has been prejudiced by the contractor's failure to provide details of his claim in a timely manner. This, while we have got rid of the condition precedent, there is still an onus on the contractor to make timely reporting of claims and provide the details. The 10.53 in the public work contracts, as John has already stated, says there would be no adjustment of the contract sum. We reversed that position in the private sector contract, and this posed some difficulties in conciliations and disputes, where that the employer, if they did nothing, or the employer's representative, if they did nothing, the change order was deemed not that there would be no adjustment. Now, if they do nothing, it's deemed that it is adjusted. So there are the main changes dealing with valuations and claims and so forth, and we've already made allusions to them. There are also changes in wordings, and I'm not going to go into them in detail, but in substantial completion, there's less of a requirement to provide all the documents. It's only the documents that are necessary for the taking over the intended purposes of the works. We haven't included, I suppose it's fair, some may have commented, and I have heard comments that we haven't included provisional sums in the contract, and the reasons for that were that it was felt that this still is an employer design contract, and it provides an element of cost certainty in carrying out the works, that we're still looking for an early design, a detailed design of the works. There are other smaller issues I draw your attention to, dealing with liquidated damages and small changes to the public works contracts, which in the time period allowed doesn't allow me to go into detail. But they're the main changes that I see of benefit to the contract and overall cooperation among the contractors and construction professionals and clients. Thank you very much.
Thank you very much, Conor, for that. Kieran, can I invite you back now to close out on the expert panel session, please?
And thank you, Paul, and good morning again to everybody. I want to talk about clause 13, which is dispute resolution, which I think is actually the shortest clause of all 13 within the conditions of contract. It's divided into 3 sub-clauses, with 13.1 dealing with what's called negotiated resolution, while 13.2 deals with adjudication and conciliation, and finally 13.3 deals with arbitration. In many ways, there are strong similarities between the PSC and the PwC in this area, and the same processes or components are used, but they're used slightly differently. And in fact, some of the changes, I suppose, are significant enough. In dealing with the first subclause 13.1, there is recognition of a project board. It's not imposed, but there's recognition that the parties may set up a project board. And after that, it actually doesn't prescribe how that is to work, unlike the PwC, which actually goes into quite a bit of detail. On the other hand, the PwC limits the function of the project board to dealing with disputes arising once EOR determinations are rejected. The scope given to the project board under this form of contract is effectively much, much broader. The relationship between the standing conciliator and the project board is dealt with, but very briefly. It's simply to the effect that the standing conciliator may attend project board meetings and may chair them. Obviously, the discretion rests with the project board. Moving on to 13.2, there's a recognition in this form of contract, as in the PwC, that payment disputes may at any time be referred to adjudication under the CCA 2013, and if that happens, any conciliation must cease or must be adjourned. Conciliation is also provided for and is very similar, but there are significant differences here. Conciliation is not set out in detail in the form of contract. Instead, it is said to be carried out in accordance with the Engineers Ireland Conciliation Procedure 2013, which, as an aside, has been reviewed, and a revised version has been adopted by Engineers Ireland and will be available very shortly. And it makes minor changes to make it, to render it suitable for use with this form of contract. One of the changes is that the period for consideration of a recommendation is reduced from 42 days to 21 days. The other, and I mean, if the recommendation, if there's no notice of dissatisfaction, the recommendation becomes final. If there is a recommendation and a notice of dissatisfaction where money is recommended, there is a significant change. Instead of the situation being that money changes hands in the event of a bond covering all of the money. The situation in this form of contract is that where money is recommended and there is a notice of dissatisfaction, 50% of the money must be paid, and the balance of the 50% is to be paid, but only against a bond covering the 50%. So that's a significant change. The other change is that in this form of contract, any dispute arising in relation to the contract may be referred to conciliation, and from there on to arbitration if necessary. That's a change from the PwC, which limits the form of dispute which can be referred to conciliation to disputes arising under the contract. The choice, sorry, this form of contract follows the choice in the PwC that the final form of dispute resolution is arbitration. The choice is essentially our litigation or arbitration, and the choice here was made for arbitration. Again, any dispute arising may be referred to arbitration. And in this instance, again, there's a reliance on the Engineers Ireland procedures. The only other significant change is that if the amount in dispute is less than 1 million, the expedited 100-day procedure must be used. And that, I suppose, is in line with there's been a movement in the arbitration world towards such expedited procedures. So that's essentially clause 13 as it is. So thank you very much.
Thank you very much, Kieran. We're now going to go into part 4 of today's launch, and I'd like to invite Eamon Conlon, solicitor, to give us his thoughts on the new private sector contract. Thank you, Eamon.
Thanks, Paul. I would like to commend the 3 bodies and the Gang of 5 for their work on this form. I haven't been involved in it up to now, although in the same way as European officials sometimes refer not to their home country but the member state with which I am most familiar, I'll admit to having some familiarity with the public works contract. But I think this form will be found useful by various bits of the private sector. I think it could be useful. It will be useful for commercial development, for industrial projects in the life sciences or power sector, for instance, in relation to civils and balance of plant projects. And also for commercial semi-state bodies who are not currently using the public works contract. I'm sure there will be some bodies for certain types of contract who will want to use internationally acceptable form when that's the constructor market that they're marketing to. But I think it will be to the good if this starts to be used instead of what we are tending to see as very heavily amended versions of the RIAI form. Versions so heavily amended that the schedule of amendments very often is longer than the RIAI form itself. And indeed, amendments that are sometimes inconsistent with clauses in the RIAI form or with other amendments, because there tends to be an accretion of amendments from project to project, and dare I say it, from law firm to law firm, so that the amendments tend to accumulate like barnacles on the hull of a boat. And this private sector form does do some of the things that perhaps necessarily amendments to the RIAI form were being used for. So, for instance, it deals with sectional completion. It deals with BIM and incorporates the CIC BIM protocol. It deals with BCAR. It has clauses dealing with programming and progress reporting. It includes an option for contractor PI. It is flexible in how it, as the public works contract is, in how it deals with risk like ground conditions and how they're to be allocated. There have been some changes from the public works contract already mentioned, and I might mention a few others. There is a specific provision in clause 8.1 that the employer is responsible for design, and not just for doing, so this is very much an employer design contract, not just for doing the design, but for integration and coordination of the design. I think that's probably implied in an employer design contract in any event, but it will perhaps concentrate the mind. And also, Conor mentioned the fact that there's an expectation that there will be a complete level of design or more complete design, and therefore there are no provisional sums. But there is in clause 813 a mechanism for ongoing design information to be provided. That's not actually provided in the public works contract. I think in the public works contract, further design information can only be provided by way of change order. But there is that provision as well, and indeed an obligation to provide further design information. So perhaps it may work where there's not necessarily a complete design. There's been a mention of nomination, and I think that would be necessary for this project, this form of contract, to be used for commercial development. And indeed, I can see how one area where there might be a temptation to introduce a sort of nom-dom type arrangement, which this contract doesn't quite have. But it would be better, I think, if the distinctions that are already in this contract were adhered to. This contract makes the employer responsible for necessary consents, and problems with consents can be a delay event. And it also imposes or leaves, you might say, the change of law risk with the employer, unlike the public works contract. There's a certain irony in that, of course. Private sector contracts traditionally, and this one also, have the risk of change of law left with the employer, whereas the public sector transfers that risk to the contractor, even though it's the public sector that makes the law. Anthony has mentioned the provision in relation to background information, which will be of concern to some employers. I would draw, and that's a thing perhaps that employers will want to watch out for. I draw attention to a few other things that employers may want to watch out for. Personally, I don't think employers will be particularly concerned about the fact that this contract introduces a limitation on liability of 100% of the initial contract sum. What might start to be a question is issues of whether the contractor actually has a balance sheet to bear that risk, and I think that may in fact be something that will be that would be queried. But there is a parent company guarantee in the public works contract that's not in this contract. I think that's appropriate, because the question of whether there should be a parent company guarantee or what additional credit enhancement will be provided by either side is something that probably needs to be decided on a case-by-case basis. There's been a removal of or a prohibition on employer assignment without contractor consent. I think many employers will be concerned about that and will be looking for either to change that, or probably better to get advanced consent to, for instance, security assignments to funders, or intragroup assignments, or perhaps assignment to a purchaser. That provision for integration and coordination may be of concern. I think will be of concern to contractors, and perhaps to employers, and perhaps some mechanism for a validation period might be appropriate, as is in some of the FIDIC forms. The employer's claim condition precedent has already been mentioned. One thing that I think employers would be concerned about is clause 351, which requires employers to put non-negligence insurance in place in every case. I'm not sure that's necessary in every case. It depends on the relationship of the works to nearby property. Also, perhaps a small point, but one I think that would be of concern, the employer's representative's time to respond to contractor submissions or object to contractor submissions has been reduced to 5 working days. And then I'll just mention 2 further points. Kieran has just talked about the mechanism for conciliation. And I think some employers will not be happy with the provision for binding conciliation. And I do wonder whether binding conciliation is in fact necessary anymore, and maybe somewhat pollutes the conciliation process. And the reason why I say I wonder is it necessary, because of course there's already the possibility of adjudication. As I say, I'm not sure that binding conciliation will be something that everyone will be happy with. And my last point is that this is an employer design contract, as I said, and as everyone has accepted. We don't really have a domestic or a homegrown design build contract for private projects. I think that this contract could, with a little bit of tweaking, be used for design build projects, but it would be good to see a version of this that would be suitable for design build. So just to conclude, to say well done to the group, and I wish this contract every success. And I think the 536 people still watching this this webinar is a tribute to the work that the Group of Five have done. Thank you.
Very much, Eamon. May I ask you to stay on as I invite the other experts back to take part in our panel discussion, which is the last section of our launch today. We've had a series of questions from attendees, and I'll try and group them together. Now, we are limited in terms of the time we have, but I might just kick off with a straightforward one. Just in terms of monetary thresholds, what size of contracts do you really see this being used for? A range of medium to large. I'll just throw it out to the panel. Maybe John, would you have an idea?
Okay, I thought Kieran was going to jump in there. I guess we don't have a fixed view as to the size of contracts. We certainly are conscious that there is a degree of administration involved in this form of contract, and that degree of administration brings a level of prelims that you wouldn't have on a smaller project. So I guess without having a fixed view in mind, like 5 million is what I had in my head as being a starting level for this type of contract. But I think, you know, that's not a fixed view. Maybe somebody might want to use it on a slightly smaller project, or indeed might form a view that it should be for projects more than 10 million. I don't know what anybody else in the panel thinks.
Well, I think it's useful and a lot less value. Not all on £10 million projects or £15 million projects, John. You know, so I think it's suitable for anything over, say, 1.5 million, 1 million, something like that. I do agree. There's a lot of administration involved in it, but they're used in the public works over 1 million, so I can't see any, and it doesn't add significantly. So you know, it's not dissimilar. It's probably simpler in that there's nominated subcontractors. So I would think a 1 million plus type of environment would be suitable, I think. But it's open to subjective opinion, I suppose.
Yeah.
It's funny, I was going to come in. I mean, I think I said earlier that I think it wasn't specified, but we all kind of knew what the figures were. And of course, we don't quite know. I would have said about 5 million, a bit like John, to be honest with you, you know, but I mean, I could accept, it depends. I mean, a complex project, say, you know, heading down, say 2 million, 1 million, that kind of thing would probably be suitable as well.
And there's me thinking I was starting off with a straightforward question. Some of the speakers alluded to, you know, the heavily amended contracts being used out there and the continuation and the proliferation of this. I mean, why would a client want to use this in a standard form rather than what is presented to them by their legal counsel, for example? Maybe Anthony or Eamon, you might have a view on that, and maybe just summarize some of the key aspects.
Well, I think as Kieran alluded to at the outset, there's a huge advantage in that the industry is familiar with the PwC. We have to remember that in the long years of the recession, the only contract in use really was the PwC because there was no private work involved. So there's a lot of young professionals in the industry who are very familiar with the PwC and are not as familiar with other forms of contract. There's also, as Eamon alluded to, you know, the disadvantage of the current situation where the amendments are growing by the day. Every new contract based on the RIAI includes all the existing amendments, and then the lawyers, to justify their crust, obviously have to have an input, and their input is usually by the addition of additional provisions, which are, as John said, very difficult usually to understand and very often are contradictory. But look, we are a standing committee. You know, the intention here is that Eamon has made some very valid points that we will certainly be looking at. And the intention here would be to amend the contract as appropriate from time to time, rather than have it amended by a whole plethora of people who, you know, have different agendas. So we'd really urge the industry, and particularly my legal colleagues, to allow us do that. If employers, on reading the contract, employer solicitors have views, we'd love to hear from them and we'll take them on board.
One other thing that I would add to that is that in this environment, it's certainly been my experience that perhaps contractors are standing up for themselves in dealing with private sector employers more than they used to. Anthony had mentioned, I think, that that making changes to the risk allocation might increase the cost. It could actually do more than that. It might reduce the list of contractors willing to tender or to contract on that basis. So that's a risk as well. I would have thought that what, you know, I'll speak to my legal colleagues too, that what would behoove lawyers to do would be to have that type of discussion with their client, to consider whether there are things about this project that require some specific mechanism or provision that's not dealt with in the contract, and clearly it is the job of a lawyer to discuss with the client what the client wants, and then to reflect those instructions. And as lawyers, we're only as good as the instructions we have. But sometimes this does start with, some of these amendments do start with the lawyer, and not even with the lawyer thinking about it, but perhaps picking up a precedent and using the glue pot and scissors or the digital equivalent. And perhaps it would be worth pausing before doing that.
Okay, I'll move on to another question. And this kind of brings together the concept of collaboration, early contract involvement, and BIM, and so forth. And I'm just wondering, with COVID-19 in mind and those three topics, what elements do you think in this contract could create a greater collaboration between contract parties to handle something like a COVID event?
Well, if I could jump in there, Paul, the obligation on the employer's representative prior to making a determination is to consult with both parties and try to reach agreement, and it expressly requires him to try and reach agreement between the parties. So it drags everybody to the table for a conversation at the very least. And failing that, the employer's representative is compelled to come up with a fair determination considering all the relevant facts. He's not tasked with, you know, acting in the employer's best interests. He's tasked with coming up with a fair determination. And I think that brings people together, and it provides for the employer's representative almost to be a quasi, I hate to use the word, a quasi decision maker as opposed to anything else, you know.
Would Kieran or Conor like to comment on?
Well, I think the entire approach, I mean, is one which is based on going back to the philosophy of, like, the ethos that I said, that thing of trying to achieve a balance between it. There's always a tension between the parties. You know, the employer has to produce the design. The contractor will always be arguing that it's insufficiently detailed or it's late or whatever. On the other hand, the employer tends to argue, this is the classic sort of thing, that the contractor hasn't applied enough resources, hasn't organized himself properly. The contract, I mean, if you come across, this attempts to sort of balance the thing, but I mean, you can't stop, no contract can stop a contract going badly wrong if the parties have entered into it and they've got the thing wrong or whatever. If you're dealing with something that arises that's completely unanticipated, we've retained, if you look at clause 4.1, the sub-clause in the PwC, which has been used to deal and initiate discussion between the parties in relation to, say, something like COVID. So it's still there. We have done the best we can, I think, to set out to maintain that spirit of cooperation in the form of contract for parties to deal with exceptional events, if you like, or things really unanticipated, storms that tend to blow everybody off course.
If I may just, sorry, Paul, just before,
Sorry, Conor, yeah, go ahead.
It's nobody, COVID was nobody's fault. It's not the contractor's nor the client's fault. So therefore, 4.17 we've actually changed that 4.127, should I say. What was contracted flexible management is now just flexible management. So that's what it needs: flexible management and cooperation to deal with it. And a practical approach is required. John is right. He's saying that, you know, a decision needs to be made at some point, but it needs to be flexible from both parties. It's neither COVID-19 is neither party's fault, but has to be dealt with.
I have 2 more questions, and because they're still racking up there on the screen, but we're running out of time. So look, I'm just going to maybe go to the concept of remeasurement in this contract, and maybe the panel will comment on the status of the bill of quantities and how potential discrepancies that may be identified there might be handled through this contract.
If I may deal with that, it's obviously 10.2, it brings up remeasurements. If there's a discrepancy in the bill of quantities, it's claimed by the contractor as soon as he's aware of it, or within 42 days of the work being carried out. There's nothing to stop him making a claim under one of the other headings, but like remeasurement is called up under 10.2. I saw that query coming up on the screen, and it was mentioned about poor bills of quantities. If there's a poor bill of quantities, it'll become apparent very quickly, and hopefully this will eradicate them. But it is up to the contractor to. Obviously, they won't be aware that it's probably not correctly measured until maybe they get involved in the contract. But unfortunately, one party has to start the claim process, I suppose, for one, which is not the intention of the contract, but it's there to solve that problem.
Yeah, and if I could jump in there as well, Paul. Yeah, the requirement is that it be done within 42 days of the works item having been completed. So for instance, within 42 days of your groundworks being finished, you'd have to have your groundworks bill of quantities items claimed if you felt there was a deficiency there. And you know, as a contractor, you're trying to chase the very lifeblood of the industry. You're trying to chase your cash flow. So of course, there's an initiative there for you to get your measurement in and get it recognized, and obviously to have the cash flowing through you from that additional work if it's there. And that'll become apparent to you from the time you start ordering materials. You know, if there's a drainage run in the bill that's 10 meters and you've to order 100 meters of drainage, well, it's going to become apparent to you long before you actually put it in the ground.
Okay. Would anybody else like to comment, or I might just close out by asking the question that people are asking, is where to next? Is this the starting point, or will this move forward to looking at new forms, other forms such as design by the contractor and so forth? And throw that maybe out to Kieran. Where's your vision for where we might go with this?
Look, I started off by pointing out that in fact this process started 7 years ago, as I would see it. And the gang of five, as Eamon Conlon called us, started meeting in 2015. And we met practically, I think we met every fortnight. We actually had meetings from February to November in 2015. And then we stopped meeting as such, but we had conference calls. I think that continued throughout 2018. So I hesitate to think of how many meetings we had. Now, that said, I was interested to hear Eamon say that this could probably be tweaked fairly easily to give a design build form. Yeah, maybe it could. I mean, I think probably what we've got to do is we've got to settle down and we've got to start working as a standing committee, and we will get response from people. And people, bear in mind, the drafting of this was finished 2 years ago, as I pointed out. There will be elements of this that will have unintended consequences. And not all of those unintended consequences will be positive. And people will be saying to us, look, you really need to take this on board, and we'll have to make those changes. So I think we'll have to move ahead on that first. And then it may well be, yes, a design build version, I suppose certainly in the longer term would have to be an option.
Okay, well, thank you. With looking at the time now, I'm going to close off the expert panel session and thank you everybody for their contributions today. I would also like to acknowledge and thank all those in the various constituent bodies, CAF, Engineers Ireland, SEI, who organised the event in such a collaborative and professional way, and particularly all the marketing teams. Anyone who wishes to get a copy of the contract, they're available on all the constituent bodies' websites. I think the links have been shared by Michelle. If you have any queries, please contact your representative body initially. And just to acknowledge that there is also an agreed domestic back-to-back subcontract available with this main form. Other than that, it's really just to close out and thank you all, and thank you all for attending, and wish everybody the best of luck. Thank you.
Thank you.
Thank you very much.